Alrighty, good afternoon, everyone. Welcome to week 10 of Principles of Commercial Law. Not long to go now that the end of term is very much in sight. And so, no doubt, if it wasn't already, I'm sure the exam is very much on your minds. I've just been asked a quick question just to repeat the content for the exam. So, in theory, the content for the exam is weeks 7 to 11. In practice, week 7 was a bit more of a theoretical discussion of legal relationships. And so the things that we talked about in terms of characterization and really tightening up our use of legal narratives, that is content that should help inform the way that you approach the exam. But in terms of substantive law, there's not really anything accessible in that week. So in terms of the substantive content, the focus very much is on weeks 8 to 11. We do have substantive content to cover in week 12. We talk about the Australian privacy principles. That's a requirement of the degree, and in particular a requirement for people doing double degrees, that they do get given that information. But in terms of just the logistics of exam preparation and everything like that, I don't think it's fair to make week 12 accessible. So the accessible exam content cuts off in week 11. Now, I'm teaching 3 subjects this term, so I lose track a little bit about what I've talked about and what I haven't talked about in each subject in relation to the exam. Have I talked you through the procedure of how the exam will work on the day? No. Okay. All right. I'll do it now, and I'll post on Moodle as well. We're just finalizing exactly the document of how that will all be written out. But basically, the way that it will work, we've got 20 something students in this unit. So it might just be me, or I might be able to get one invigilation support. So you'll either get, basically, the exam is invigilated. And so what that means is you'll have to complete the exam in front of, or on your computer, but with Zoom on and with your camera on, with your sound on, so that you can be observed or invigilated, basically to just make sure that you're not talking to anyone else and not cheating.
Just to clarify on that, Jacob, is that only the
Yes.
accounting students, or are we law students also doing invigilated now? Because at the beginning of term, you said
Oh,
that
that's
we
right.
weren't.
Yes. Yeah. No, that's
So
very
just
true.
to be clear.
Yeah, no. That's a good point. I forgot. This is a problem doing the 3 subjects. Yeah. So if you're not doing accounting, you won't be invigilated. If you want to be invigilated, I don't necessarily know why you would want to, but if you felt like, because I'll be okay, well, so there's far fewer accounting students as well, so it will definitely just be the one room. So it will just be me doing the invigilation. And so I can see a scenario where there's a question about the exam that pops up, and I would clarify, uh, section 8, there's a typo or something. If something like that happened, I would post on Teams so that people who aren't part of the invigilation would get that information too. But if you wanted to be part of the invigilated exam, so that you got that benefit in live terms, then you'd be welcome to as well. But basically, there'll be a Zoom room that you'll log into if you're part of the invigilated exam. You'll need to rock up. So the exam starts at 9. You'll need to rock up about 15 minutes early to show ID, just to prove that you are who is enrolled. A driver's license is perfectly fine, and in fact would be great ID. I think technically we're supposed to ask for student cards, but being an online university, I think a lot of students don't necessarily have student cards, so driver's license is more than fine. So we'll do an ID check, and then the exam itself will go live on Moodle at 9 a.m. On Moodle, it says the exam starts at 10. I'm wondering if that's a New South Wales thing. Did I do,
Yeah, it
or
says
did I
10
do
to 12 on there.
10 to 12? That sounds better. Sorry, I'm getting all the exams mixed up. 10 to 12 sounds right. I will triple check and I'll post on Moodle and Teams, but 10 to 12, that sounds right. My other subjects are 9, but 10 o'clock's better. So 10 to 12, excellent. So 9:45, log in, we'll do the ID checks. Exam goes live at 10 on Moodle. People who are doing the invigilated exam, you'll need to have your camera on and your sound on, as I've said. You can, from your own computer, you can turn your sound down so that you're not hearing everyone else's computers clicking and, if someone coughs and that sort of thing. But your microphone needs to be on so that I can hear all your keyboards clicking and hear if someone, if you're talking to someone, basically. So that's how that will work. You'll then have the 2 hours to submit. These times are all in Queensland time as well, by the way. You'll submit via Moodle, and then that'll be the process. So yeah, if you're not doing the accounting degree and if you're not wanting to take part in the invigilated process, which is perfectly fine, it will just be sort of the normal take-home exam procedure. So it will be the same thing. The exam still goes live at 10 a.m. You're still not allowed to talk to anyone or communicate with anyone about the exam, but you don't have to be observed while you're doing it, and you make that submission by the 12 o'clock deadline as well. So, it's relatively straightforward, but with a few add-ons or tweaks compared to, for those of you who are used to doing take-home papers in the past. If you're doing the invigilation one now, it's, probably will be a little bit of an adjustment, but my big advice is that on your own computer, you turn the sound down, just so that you don't have to hear everyone's keyboards clicking and coughing and that sort of stuff. Any other questions about the exam and I suppose the logistics of how it might work on the day?
You said before that you'll post on Teams if there's any issues with the exam paper or anything. Is that going to go under the general tab on
Yes.
Teams?
Yep. Yeah. So let's say, and it will only be, obviously I'm not going to be for those who are doing the take home exam, I'm not going to be in the invigilated exam giving people like help or anything like that. It'll just be like if there was a typo or some sort of clarification that has some impact on the way that you approach the exam. And so what I'd obviously answer the question in the moment in the exam. I'd make a post on Teams straight away because that's the most instantaneous form of communication I can give you. And then I'd send out an email via Moodle as well. And then that way, that's going directly to your email box. I can make sure that you're getting that information. It just takes a little longer to set up. So that would be the third step in the process. But
I guess I
looked
at it though, Jacob, you've only got 2 hours, and I
know
that you don't get time in a 4-hour exam to check. We had an exam last term or earlier this term it was, where there was an announcement put out on Moodle, which was great. But if you're not looking for it, then you're finding about it after the fact, which to whose detriment? Who would look at Moodle or Teams in exam time?
That's fair enough. My suggestion would be with Teams, you can turn notifications on for that general channel. So then you can just have Teams open in the background. And if something comes up, you'll just get the little bing. So yeah, I mean, it's a
chances are slim we'll need it.
Chances are, well, that's what I was going to say. Like, I can't guarantee that it absolutely won't happen, but I think I haven't had to send out a clarification regarding an exam since 2020. So it's, not saying that it won't happen, but the odds are low. And if it needed to happen, I think that's the best thing that I can do, or the fairest thing that I can do, to make sure that you've got the opportunity to be notified. Yeah. Any other questions?
Yeah, I do.
Yep.
So it's a memorial memorandum.
Yes.
And the word count, how much was that again?
So we've talked previously, and I don't think I've given the exact word. I'm setting the word count at 1,000 words. And I think that will be more than enough. I wouldn't expect that you would need heaps more than that. What I'll do as well is, that's not that won't be a super strict, if you go over 1,000 words, I stop reading it and I'll never speak to you again. It will be, it's more that what I want to avoid is just copying, because, technically on the marking criteria, if you uploaded as your answer all the study guides, let's say, technically on the marking criteria, you will have identified all the relevant rules. Like all the relevant legislation and all the case law would technically be within your answer. There would be no application, but in terms of identifying the relevant rules, technically all those elements would be there. And that's an extreme example, but I want to avoid a scenario where there are scattergun answers that just try and just dump everything in the hopes that something is relevant. I do want to encourage answers that are, refined and focused to the issues as much as you can, and balance that with, it's a 2-hour exam. You don't have a ton of time to be editing down and that sort of thing. So it's 1,000 words. If you strayed over to 1,100, 1,200, it's not a problem. If you submitted 2,500 words, that's an issue. But yeah, so 1,000 words will be the soft word limit.
And what about, so with referencing, is acronyms all right? And like, how strict are you with that?
So what you need to do, so there's sort of, your referencing needs to be appropriate, but doesn't need to be perfect. And so what I mean by that is that you still need to be making sure that you're providing references in the right spot. So the relevant legislation, the relevant cases, those still need to be cited, and any ideas that are not your own, there needs to be a reference for that. It would be great, given that it's an online exam, and you've got in your notes, you've got the opportunity to get all the referencing right, and you just copy that across into your footnotes. It would be great if the referencing is, matches what would be expected under AGLC 4th edition. But that particular part of it won't be strictly applied. The footnoting's still got to be, it's got to be clear what you're referencing or referring to. But especially things like IBID or above N5, all that sort of stuff, I wouldn't worry about. Case name and year, I would say, is the minimum, and then volume and report and starting page number would be great. But if in the stress of the exam it doesn't make it into the footnote, as long as it's still clear what the case is, that's the minimum that I'd be looking for. And so when I say, adequate but doesn't have to be perfect, it's got to be clear what you're referring to, but it doesn't have to be AGLC 4th edition, absolute, perfect, tick, all the boxes. Does that make sense?
Yeah, that's good. And does the word count and the referencing, are they combined,
So
or
footnotes won't be included, no. As long as they're just referencing, so no substantive content in the footnotes. But yeah, footnotes don't need to be added into the word count.
okay, thank you.
And I suppose on a similar note, there's no need for a reference list at the end. I think that's within 2 hours. There's no need for that as well. Cool. Any other exam related questions?
Just one, please, Jacob. Oh, you
Yeah,
may have already covered this. Sorry if you have. I just had to duck away from my computer for a moment.
No, that's okay.
With the invigilated link, does it go in the submission area of the assessment tile?
What I'll do,
Zoom?
yeah. So what I'll do, because it needs to be available to you before the exam itself opens, obviously. What I'll do, I'll post it. I'll find the best spot for it in Teams, which will probably be under the assessment tile, but not under the exam link. I'll also, students who are in the accounting degree, I'll also email separately and contact them directly with the link as well.
Okay, sounds great. Because last term we kicked off with this in evidence and proof, and it was mass mayhem. It was just so terrible. People not getting their links, and they wasted about 20 minutes of the exam, and the poor lecturer was just pulling his hair out.
Yeah, it's last term was the first year of, I guess, first instance of doing that. And it's a process that's going to be, I mean, you guys are doing other subjects, as well. It's rolling out across the degree. So yeah, it's something that we're all still learning a bit. But yeah, I'll make sure that there's people who directly, people in the accounting degree who have to take part in the invigilated exam, they'll be emailed the link directly. I'll then post it in Moodle as another source of being able to find that, but then also for other students who want to be part of the invigilation. And then I'll make the posts in Moodle and Teams, letting you know exactly where that is. And I'll include the link there as well, I suppose.
Excellent. Thank you.
Yep, no worries.
And are you going to do a bit of a pre-document for this exam with the rubric and everything attached, or is that just going to be on the day?
Yeah, so the rubric, the marking standards are the same as the midterm in terms of what's expected, knowledge of the rules, application, and in particular the focus being on knowledge of the rules being important, but then critical application being the most important individual criteria. So yeah, it's the same effectively as the midterm one.
Would you do sort of like a hints sheet or like a guide kind of?
As in how to prepare, or as in what should you study?
What should you study?
I mean, it's between weeks 8 to 11. The content is not, it's not like you're trying to condense 12 weeks worth of stuff into your notes. So I wasn't thinking that I'd be giving even narrower focus than focus on these 4 weeks. In terms of how to prepare, I think we've discussed in previous weeks around some of the note-taking strategies and some of the techniques that you can be doing to most efficiently make use of your preparation before the exam. And yeah, I suppose it's those same points would stand. Yeah, in terms of in terms of content that you should or shouldn't focus on, I mean, I think in previous weeks we talked about focus your main attention on the areas that have received the most attention in the lectures, or focus your efforts in proportion to the amount of time that they're discussed in the lectures and study guides. So for example, week 8, we spend a lot of time looking at misleading and deceptive conduct. It makes sense to put more of your effort on that compared to, say, bait advertising or something. Other than that, yeah, I think that there's enough, you know. I think any more than that starts to get to limits the preparation too much, and you do need to be across all the issues to be adequately assessed.
Okay, great. Thank you.
That's all good.
Is the example that we worked with last week, is that being put on Moodle? I think it was like a example memorandum that you did for Cartel.
Yes. I thought I had uploaded it. Maybe it didn't save. I'll double check after this. It should be up under the week 9.
It's under the learning activities example memo of advice, Nicole.
It's there because I
okay, excellent. Okay, so under the week 9 tile, that's up there.
Thank you.
No
Just
worries.
scroll down a bit further though, Nicole, because it's under the learning activities, not where all the other documents are.
No worries. Thanks.
Right. Okay. Fantastic. Maybe if there's other exam questions, maybe post them up on Teams after this, because I am conscious that we do have a tutorial's worth of content to go through as well. So let's talk about credit law and in particular the ways in which the National Credit Code attempts to protect people in a credit situation. So the key take homes, or the key things that I'd like you to be thinking about in relation to this topic are paying close attention to the objectives of the National Credit Code and being able to work through the nuances of the way the credit code does and doesn't apply, but appreciating and being able to link back to these broader protections which aim to protect ordinary debtors or consumers. So when we think, for example, about and we'll talk in more detail in question 2 about this, but we think about who the credit code does and doesn't apply to, being able to recognize that, you know, the entities like corporations that the credit code doesn't apply to, the rationale being the credit code is there to protect what we might call ordinary debtors, rather than corporations or these legal entities that presumably, although of course not always in practice, but presumably have access to legal advice or additional let's say protections, in the sense that you know, a private corporation itself protects the shareholders and the directors and that sort of thing. So the objective with the NCC is to protect ordinary debtors. And so being able to recognize in the scenarios when the NCC does and doesn't apply is a really important step. And then beyond that, being able to work through the nuances of the enforcement process is really important, and being able to identify the various requirements and whether or not those have been met, or to apply a more nuanced perspective, arguably whether those have or haven't been met. If you're going to get credit applications, credit questions in the assessment, those are the types of things that that leap out as being the kinds of issues that give the most fodder for an interesting discussion, let's say. So with that in mind, question 1 asks, what is the procedure for a credit provider enforcing a mortgage over goods? So we don't necessarily, I think in the time, it makes sense for us to spend more time on question 2, but we'll breeze through question 1. So we don't necessarily have to go through in systematic detail, but what are the core things or core provisions that we should be thinking about in relation to enforcement?
Firstly, the credit provider must ascertain that the debtor has defaulted by reason of being behind in payments.
Yep. So there has to be
the credit provider
a default.
Yep. Secondly, the credit provider has given the debtor or any guarantor a default notice complying with Section 88, allowing the debtor a period of at least 30 days from the date of notice to remedy the default. Okay. Now, that if the default hasn't been remedied by that period, and if the creditor or if the credit contract is for a reverse mortgage, I won't go into that.
Yeah.
Now, the enforcement of a mortgage, send a notice of default notice requirements. So default notice must contain a prominent heading stating that it is a default notice, and specify the default and the action necessary to remedy the default, and specify a period for remedying the default and the date after which enforcement proceedings in relation to the default, if relevant, repossession of a mortgaged property may begin if the default has not been remedied. So they're the first sections of that. So they're the procedures of commencing a default action for a mortgage.
Yep. So, yeah, great answer. And really paying attention to the process of or the separation between the initial notice that the account is in default and the identifying the steps that can be taken to remedy the situation, i.e. pay the debt or make the payments that are due, that 30-day window, and then the account still remains in default after that period has come to an end. There was, and the reason I'm making a bigger deal of that is a few years ago I did an assessment question where there was the notice of the default, but then it was proposed to be taking action straight away, and that 30-day window wasn't accounted for or present in the factual scenario, and a lot of people kind of missed that, and they just sort of jumped straight into talking about the hardship provisions and that sort of stuff, and didn't actually acknowledge, well, there's 30 days to get this sorted before we then have to look into all these other issues. So just paying a really close attention to that one. What about the PPSA and the way that potentially interacts with some of these enforcement procedures as well?
It says that it may be under the credit reporting's file, so we can, if it's overdue for 60 days or more.
So in terms of, so that's sorry, okay. Acronyms. So the Personal Property Security Act and Personal Property Security Register is where I was going. But you are right that under the Privacy Act, there are also options for reporting, and if the account remains in default, it gets added to people's files as well. Yeah, you're absolutely right. So too many acronyms with A's and P's in this unit. So it's the Privacy Act and the APPs, which we talk about in week 12. What about the Personal Property Security Register?
I just remember, I don't have anything written in the answer about it, but maybe if they needed to enforce something against a third party, a guarantee or something. I think I remember reading something about that.
If they
Yeah.
put a motor vehicle or something like that with no security over that, that the bank could look at putting some sort of security over that asset.
Yeah, so it's sort of. So it's if you're the credit provider over goods to which the PPSR might apply, ideally what you would have done is when the loan was first granted and you acquired a security interest in that good, you would have registered it. And so from an enforcement perspective at the end, that gives the creditor security around enforcement. They don't necessarily have to seek a court order to have that interest recognized. But additionally, where there are multiple parties that have an interest in that good, the order in which they're registered under the PPSR sets out who takes priorities, or let's say that the good is then sold to satisfy the debt. The prior registered parties get paid out first, and then if there's money left over, then it goes to the lower ranked secured parties. So in terms of the enforcement process, factoring in the PPSR is important as well. I think to Jason's point, if you're wouldn't necessarily be a third party, but if you're a lower ranked, or if your security interest was not registered and there were other interests that were registered, then in terms of enforcement, you'd lose out in comparison to those prior registered interests as well. So just being aware of that as a potential other factor in the enforcement process as well is important. But let's press on and focus on question 2. So problem 2, Tony's a bricklaying subcontractor working through his company, Tonbrick Proprietary Limited. He needs a new ute, but also decides that he needs something that can run his family around too, and in particular drop them off at school and those sorts of things. He buys the truck through his company for tax reasons. The price from the dealer is 25 grand, and he pays 15 grand cash and agrees with the dealer to pay the balance in 2 monthly installments of $5,000. Does the NCC apply to this transaction? So we should have a very quick answer, and then we'll tweak the facts slightly to give ourselves a bit longer answer as well. So does the NCC apply or not?
Off the bat, it appears that it doesn't apply because he's buying it through the company for work purposes predominantly. So the predominant purpose is for work, and the secondary purposes are for running the kids to school and a few excursions here and there for the kids. So off the bat, it wouldn't appear that it's for a code purpose. The code purpose is for personal, domestic type of arrangements. And because he's a corporation, he's buying and he's registered under a corporation, that also invalidates the code purpose as well.
Okay. Jason, I saw you had your mic off. I'll get you to weigh in too before I comment.
Well, I guess, yeah, first I had to work out if it was defined as a credit activity, which as a credit sounded like a credit contract. and just noted that under section 29, a person who engages in that activity needs to be licensed. And then I went through section 5, which has the requirements which need to be satisfied, which I think, the debtor has to be a natural person. Was the charge made for the credit? Was the predominant purpose personal? Was the credit provided in the course of business, and are there any exceptions? So pretty much what Bill said, I think I concluded that it didn't appear to apply because his purpose appears primarily personal. There's no charge made for the credit either. It doesn't seem like there's no interest on that loan. And I think there was another thing too, something about the code doesn't apply to short-term credit where credit's provided for no more than 62 days, and that loan was paid in 2 months over 2 5,000 installments.
Is that section 6?
I forget somewhere. That's just in the conclusion. I don't have it noted.
I think
And
it's section 6.
interest rates don't exceed something 24%.
Yeah. Well, so let's break that down, because the very quick answer is that as you both noted, under section 5(1)(a), the debtor must be a natural person, and this ute is being bought through Tonbrick. It seems on the facts as though the payment, and you're right to pick up the details of, like, is this actually a provision of credit or not? But for now, let's say it is. It seems as though that's being done through the company, which is not a natural person. And so straight off the bat, under 5(1)(a), the NCC wouldn't apply to this scenario. Just to give ourselves a bit more to discuss and debate, let's pretend that he didn't buy it through the company. He bought it in his own right as a natural person. And therefore, at least under 5(1)(a), the NCC could apply. Then you're very right that we're thinking about section 5(1)(b), that the credit must be provided wholly or predominantly for personal, domestic, or household purposes. Now, Bill and Jason have both reached a conclusion that it's not. There's this significant work purpose as well. But I think we can have, I would say on balance that conclusion is the right one to reach. But in the interests of providing a nuanced and more analytical answer, we can actually go into a bit more depth. It doesn't have to be such a foregone conclusion on that front. So let's open up the discussion on this issue of is it for domestic or personal use. So I suppose Bill and Jason have already presented arguments that they think that it wouldn't be. I saw you both your microphones off though, so maybe you want to add more of that as well.
Someone else can add.
Go for it, Jason.
Oh, I was just going to say, yeah, that there's more we could say on that. It said in the facts the purpose was to drop the kids off at school and at various events, and then it sort of just mentioned his business and so on. So sort of the inference there was, dropping the kids off at school is a relatively short thing that didn't appear to be primarily for a personal use. But of course, he could have a whole bunch of children. They could have lots of events, and it could ultimately get him over that 50%. So, it's worth, I suppose, noting and just sort of saying, well, it appears this way, but maybe there's further information that could get him over that 50%.
Yeah.
Also, wouldn't you establish whether there was a declaration as to purpose? And initially, when he went for the loan or purchased the vehicle, to find out what the purpose was for it, and then after that run section 6, which is provision of the credit to which the code does not apply, to find out how well. It's 2 months, so it's presumably 61 days. So it falls outside the beyond 62, greater than 62 days, and there's no interest or other fees to be paid. So if it meets Section 6, then the NCC does not apply to credit contracts. And then I think a charge must be made for the credit, which covers all that on Section 6. I think sections 51C and Section 6 as well. So it fails that test as well.
Yep. Yeah. Well, and as we go through, you have noticed already, we're basically just looking at all the different ways why the NCC doesn't apply, and then tweaking it to talk about other things as well. But yeah, you're very right. There's issues with Section 6 as well. On the issue of is it for did he sign the declaration of purpose? That's a great observation, and it's an important one. Let's say he signed it, and then after the fact changed its use. There's potentially issues there as well. But just on the, let's say there was no declaration. Let's just say that it's on the facts as presented. As Jason said, there's potentially some investigation that we can do around, how much family taxiing he does with this car versus how much use he's getting out of it as a work vehicle. But we also need to think about these competing lines of inquiry in the case law about what the frame of reference should be, in terms of, should we look at it from the perspective of what would the credit provider have reasonably understood that purpose to be? Or should we be looking at just the substance of the transaction itself and focusing on the way in which, just on the transaction, what the purpose appears to be, or what the substance of the transaction would indicate to us. And so a really great answer in this space would note those competing lines of inquiry and discuss whether or not that those different lines of inquiry might change the answer or not. To the extent that if we could establish that Tony's got 6 kids that go to 6 different schools and go to music lessons and sport all afternoon and all weekend, and he just he basically lives in this car outside of work just driving kids to different things, then you could make the argument that under the substance of the transaction there's that domestic purpose. But if the line of inquiry is to be what the credit provider would reasonably have understood the purpose to be, I think we'd make we'd have a pretty solid argument that the credit provider's reasonable interpretation would be consistent with the answers that Bill and Jason gave at the start, and that probably others have come to as well, in that when you hear about, I need to buy a ute, I also probably need to drop the kids off at school. In your mind, you most likely are ranking that as this is for work first, and then these sort of family uses are a smaller or secondary use. And so on these facts, I think you'd have a strong argument the credit provider would reasonably have understood this to be a work thing. And so noting these competing lines of inquiry, these competing judgments, and noting that potentially they lead you to different outcomes or different conclusions is a really great way to highlight the your critical analysis and your understanding of the law in this area. Does that make sense?
Yeah, what I said was that the vehicle is a utility, and therefore prima facie there's an inference that the utility vehicles are purchased predominantly for tradespeople to travel to and from their place of work and for usage in business related and trade related employment.
Yeah, there's I mean, it's difficult because, and I mean, you know, on the facts as they're originally presented, he's buying it through his bricklaying company, which I think is a pretty big giveaway as well. But if we've tweaked it so that it's not going through the company so that the NCC potentially applies, then maybe we lose that. You know, someone might buy a ute because they, I don't know, they've got a boat that they love to take out on the weekend and they need to be able to tow and that sort of stuff. So, you know, it's conceivable that not every ute is being bought for work purposes. So part of it probably comes down to on the facts. You know, he comes in and he says, I'm a bricklayer, I need a new ute. I think that puts the credit provider in a position where they're thinking, okay, this is a work ute. But yeah, if he'd come in and said, you know, my children are hardcore wakeboarders and we spend all weekend taking the boat out to the lake and doing that sort of stuff. I need a ute that can tow my boat. Maybe they reasonably understand the purpose to be for something different. So there's an element there of we would need more information, need more facts. But I would also agree that on the facts that we're given at the moment, the most likely outcome or the most reasonable understanding that the credit provider comes to is that this is a work ute. It's for work or commercial purposes. I think you'd have a strong argument there.
And the case authority also was Park Avenue nominees.
Yep.
Where the court, when they were making reference to Rafiki, they said that the intention for which credit was sought is to be determined by an objective test. That is, what a reasonable person standing in the shoes of the credit provider would have understood the predominant purpose for which the credit was provided.
Yep. Yeah. So I think, and you know, part of this comes down to, we've talked before, obviously, about these legal narratives and coming up with the position that is more persuasive for the client's interests. If you're the bank or the credit provider, the car dealer, you're arguing that the right test is what the credit provider reasonably understood, and this was the reasonable understanding. If you're Tony, you're probably saying that the substance of the transaction is the right test, and you know, bringing in Lincoln Holt and some of these other cases to say we should be looking at the substance of the transaction and maybe bringing in additional information that we don't have around how much personal or domestic use he's getting out of this thing, to indicate that this does have a I think wholly's out of the question, but predominantly personal or domestic purpose. Just using the differing perspectives to inform the line of argument that you might preference. But either way, you know, if he signed a declaration of purpose, then that blows all of that discussion out of the water as well. So as has been raised as well, thinking about the whether there's been a charge for the credit, that's obviously an issue here. Some of the issues around Section 6 and the time limits, problems there as well. We've also potentially got problems under Section 11 around the sale by installments, where the installment payments must exceed the cash price of the goods. and it seems that in this instance that that it wouldn't meet the criteria under Section 11 as well. So plenty of problems for Tony, plenty of reasons why the NCC wouldn't apply to this transaction. But I think it's useful for us to approach a scenario and a question where we're taking notice of all these issues and being able to identify it doesn't apply because of this, it doesn't apply because of that. Just, I think with these tutorial questions, it's often the presumption is that it does apply or they are protected and those sorts of things. So useful for us to think about something that goes the other way. Let's say by some miracle and by tweaking a lot of the facts that the NCC did apply. Let's say he's paid the 15 grand cash. He's paid the first monthly installment and then which had interest attached to it, just so that we meet those criteria as well. Let's say there were 3 monthly installments rather than 2, just to extend the time out as well. He makes the first one and then misses the second one. What might be the process from there?
Enforcement.
Yep. So thinking through those ideas that we talked about in question 1 around being provided with the notice and those sorts of things. Let's say that the reason that he hadn't made the payment was because the with inflation skyrocketing, all the demand for bricklaying has completely dried up and he just can't get any business at all. All the leads have run dry and he can't actually get any new consumers. So he's got no income. He can't, and that's why he can't make the payments. What advice or what suggestions might we make to Tony about, his options?
Probably some hardship provisions.
Yep. Fantastic. I know this was a bit of a question without notice, but can anyone give a little bit more detail on that one?
See a free financial counsellor to see what his options might be.
Yeah.
And then refer to section 72 to 75 of the NCC about the variation of grounds for hardship.
Yep. Fantastic. So, and when we're thinking about hardship, the getting financial advice is a very good step. But in particular, thinking about the hardship provisions, looking at the options for varying the terms or going through some sort of dispute resolution to work out a solution that, at the end of the day, the debt still needs to be serviced, but just coming up with a way of doing that's I suppose more achievable or will result in ultimately the creditor being able to get the money that they are owed, rather than just a complete default and going through those enforcement procedures. So just being aware of those and aware of those options as well is useful and important. Any other questions or comments on that one?
I noticed that the Australian Consumer Act steps in some situations. I can see myself getting really confused with what legislation's going to be. I guess it would only be in certain situations if it was misleading or deceptive conduct, or is that?
Right. Oh, okay. As in, so, yeah, okay. So I guess thinking potentially about a scenario where you've got someone who goes in and goes to buy something, let's say a computer, something that the ACL applies to, and they're misled. There's some sort of issue around the conduct in relation to buying the computer, but then on top of that, they need to get a loan, and there's misconduct around the terms of the loan or something like that as well. Is that sort of what you're getting at? There's
Yeah, because it's because I just noticed it says what happens if you provide false and misleading information, and then it says you must not give ASIC. Yeah, so that is, I just noticed that came into it. You'll be issued an infringement notice or a civil penalty.
So the key way that you distinguish that, and I'm answering more from the perspective of the exam. The main thing to think about is, does the conduct attach to the good? Attach is not the right word, but is the conduct focused on getting you to buy or enter into the transaction itself, or is the conduct focused on the loan? So let's say let's stick with the computer example. You distinguish between the salesperson saying this computer's fantastic, it's top of the line, can do everything that you'd absolutely ever need it to do, and then you buy it and it turns out that it was complete junk and it's really slow and it doesn't turn on properly or whatever, versus you get there, you want to buy this computer and everything that was said about the computer is true, but you get told, oh, you can, if you don't have the money, you can finance this purchase, $0 up front, and it's really cheap repayments after that. And then it turns out that the really cheap repayments, that's not true. There's a huge interest rate, and so there's misleading and deceptive conduct around the terms of the loan or that sort of thing. So paying particular attention to the facts and what the misleading or deceptive conduct is relating to. Is it going towards the goods or inducing the person into buying the good, or is it focusing on the terms of the loan, or is it attaching to the provision of credit, and distinguishing your answer in relation to that, I think, is the easiest way forward in an exam scenario.
Okay, thank you.
That's all right. Any other questions or comments before we leave it there? No, fantastic. All righty. Well, thanks everyone for coming along. Next week is our final week of content that's examinable. We're looking at e-commerce and some of the ways in which developing computing technologies are changing or modifying the way that we think about commercial law and some of these key principles that we're looking at. So looking forward to seeing you all for that one, and I'll catch you then. Thanks very much. Bye.
Thanks, Jacob.